So let me tell you a little bit about Mark. Mark's been serving immigration and Social Security disability clients at AVAR Law offices since 2010. Before joining AVAR Law as an associate attorney, he handled complex criminal appellate work at the Michigan Attorney General's office and has worked on a variety of civil matters at the Civil Attorney's Office in Michigan. He has expertise in various stages of the Social Security process, and he has successfully advocated for hundreds of claimants, both at the hearing level and before the Social Security Appeals Council, both in Florida and across the country. PowerPoint?
Yes.
You do.
Good afternoon, everyone. And to summarize Tom's presentation of me, my name is Mark Zakhvatayev. I work with AVAR Law offices, and my presentation today deals with musculoskeletal impairments and how to prove them and how the limitations from these impairments are applied throughout the sequential disability process. So what are musculoskeletal disorders? These are joint dysfunction, spine dysfunction, fractures, amputations, and even soft tissue injuries such as burns. They may also overlap with other types of disorders. For instance, immune system disorders, such disorders as rheumatoid arthritis, affect joints and therefore affects the musculoskeletal system. So in order to prove the existence of a musculoskeletal disorder, you must have a medically determinable impairment, and it must be established by medical science and by laboratory findings. And the agency revised the definition of medical science and also the laboratory findings in the cited regulations and also in the Social Security Ruling 16-3P. The science means basically abnormalities that can be observed as opposed to individual complaints and complaints of individual symptoms. They must be shown by medically acceptable clinical diagnostic techniques. The laboratory findings means one or more anatomical, physiological, or psychological phenomena that can be shown by the use of medically acceptable laboratory diagnostic techniques. Examples of medical signs are reduced joint range of motion, muscle spasms, sensory deficits, and motor disruptions. All of those can be observed either visually or using the laboratory technique findings. Social Security Administration will not substitute the individual's allegations of pain for missing or deficient science or missing or deficient diagnostic techniques. So it's, of course, best to use the objective evidence in your case. One of the objective tests is a muscle strength test, which is a test that measures the muscle strength on a scale from 0 to 5. And SSA recently, back in May, proposed some new regulations which will modify the listings, and it actually includes the explanation of this muscle strength test in the appendix to the listings. Some of the common sign tests, number one is the Tinel sign test, which is used to detect nerve irritation in hands. There's Phelan sign test, which is used to detect carpal tunnel syndrome. There is straight leg raising test, which is used to detect the herniations in the lumbar spine. There's Faber test, which is used to detect the joint dysfunction or the hip dysfunction or the dysfunctions in the sacroiliac region. Some of the common examples of laboratory techniques are the blood work, the EKGs, which are used to detect the heart abnormalities, the EEGs, which are used to detect seizure activities, and then more relevant to musculoskeletal disorders, the EMGs, nerve conduction studies, which are used to detect nerve damage, and then the MRIs, the X-rays, the CT scans, and similar tests used to detect the abnormalities in the soft tissue and also bone abnormalities. And a side slide about the blood work. Usually it helps establishing immune diseases, but those can be relevant to the musculoskeletal disorders because they do affect joints. And you would want to look for CPK test results in the blood work, which can indicate muscle inflammation, heart injury, kidney injury. The ESR test, which is used to detect, again, inflammation in the body, such as arthritis in the body and joints. And then the C-reactive protein test, which is used for detecting, again, the inflammation in the body and helps identifying different arthritis impairments and also the ankylosing spondylitis. The limitations from musculoskeletal disorders can be exertional and non-exertional. Exertional limitations are the limitations on lifting, sitting, standing. The non-exertional limitations that can be caused by the musculoskeletal impairments are postural, manipulative limitations, environmental, sensory, and even mental limitations such as pain. For example, joint pain that could cause the problems with concentration, focusing, and also the individual's ability to interact with other people. And next, we need to formulate the RFC for the client. We need to focus questions on quantifying the abilities to sit, stand, and walk. Ask how long the individual can sit, stand, walk. What happens if these activities are performed for too long? Does the individual need to get up? Does the individual need to lie down? And can these activities be performed at the same rate as the workday progresses? For example, if the individual stood or sat for an hour and then they took a break for 15-20 minutes, can they go back and do the same amount of sitting for an hour again? We need to develop the testimony regarding the alternating between different positions and between sitting and standing, or even if the individual remains seated, the squirming, the leaning, the shifting, those could also affect the work pace of the individual. Other impairments can affect or exacerbate musculoskeletal impairments. One of them is obesity, and the agency provides guidance on how to analyze the obesity and how it impacts musculoskeletal impairments in the Social Security Ruling 02-1P. Musculoskeletal impairments, as I mentioned earlier, could cause some mental impairments, emotional overlay, and there are tests that can be done to detect the amount of, or detect the emotional problems caused by the musculoskeletal impairments. For instance, the MMPI test helps identify the somatic complaints, which are the unexplained physical complaints, or the Waddell signs, which are used to detect non-organic or psychological component to chronic low back pain. And the agency used that Waddell signs in the past to detect malingering as well. We could use the medical opinions to determine the limitations from the musculoskeletal impairments. As we all know, Social Security has modified the rules on the way it's treating medical opinion evidence, the way it's treating the treating physician's opinion. It no longer gives control and weight to the treating physicians, and the two major factors that the agency looks at right now are supportability and consistency of the medical opinion with the rest of the medical evidence. This is an example of the medical source statement, which we put up here with Mr. Thomas Bush's permission. It asks questions about the length of treatment, the diagnosis, the prognosis, and then goes on asking questions about the limitations that the individual has. And There are multiple pages to this, and we have that in the written materials. One slide up here, which is a follow-up medical source statement. In the previous presentation, we were talking about the usefulness of the medical source statements, and this, I think, could help with improve the validity of the medical source statement, a follow-up questionnaire to the doctor if the doctor didn't miss or missed certain things or didn't hit the critical points that you needed answered on the medical source statement. You could send them a follow-up medical source statement form like this or a modified version of this form, and that could help. At step 4, we'll look at how the musculoskeletal disorders affect the individual's ability to perform past relevant work, and you need to develop the testimony concerning both physical and mental demands of past relevant work, as the AAJ at step 4 will then apply that to the physical and mental requirements of past work, and be mindful of composite jobs, which are jobs that by definition have involve significant duties of more than one occupation. And with composite jobs, especially for people who are older, if you have a composite job, there's case law, and then there are also some agency publications which state that the judges should not, or the agent, or the state agency should not apply or should not find that the individual can perform past relevant work as generally performed if it's a composite job. And in that case, you just focus on the job as actually performed. And showing that a job is a composite job doesn't get you off the hook, because if you still show, even if it involved more than one, significant duties for more than one occupation, the judge could still find that you could do the past relevant work as actually performed. And also look out for accommodations, even if the V testified that the job or the employers does not generally require use of a stool or do not allow for a sit-stand option. If the individual performed that job themselves and were allowed to use a stool or were allowed to alternate between sitting and standing, then you have a problem, because the judge may find that your client can perform the past relevant work. At step 5, you need to translate the limitations from the musculoskeletal impairments into limitations, and your questions must be specific. You must define what you mean by certain restrictions. If you talk about reaching or handling, fingering, you need to say whether it's occasional, frequent, and so on. Do not include the limitations such as mild or moderate in the hypothetical questions. You need to quantify those. Low stress work, what does that mean? Does that mean that the individual has difficulty focusing when they're stressed, or does the individual have difficulty interacting with other people? And avoid asking hypothetical questions that include all of the limitations. And the reason for that the judge may not adopt all of the limitations that you have in the RFC that you presented, and that may help identifying the impact of each limitation or restriction separately on the occupational base. One of the scales or tools that we feel is overlooked is the aptitude scale, which is available in each job description for each job in the DOT and its companion publication SCO, and it's a 5-point scale. Number 1 is top 10%. So if the individual could perform something, say handling, for 90% of the time, they could still be found to be unable to perform that job if that job requires or has one foreign aptitude, basically requiring manual dexterity more than 90% of the time. This scale comes from a credible source. It's published in each DOT description. It comes from the U.S. Department of Labor, and you can argue that the AAJ or this should take administrative notice of this information. The examples of improper V questions, questions regarding credibility, that's for the judge to determine. V's should not be provided in medical opinion. It's improper for the ALJ to impose a hypothetical or pose a hypothetical question that does not include all of the limitations. If the judge later adopts that hypothetical question, the decision, then that decision would not be supported by substantial evidence. Vocational experts are told to primarily use the Dictionary of Occupational Titles. However, the problem with that, the Dictionary of Occupational, the Department of Labor stopped revising the Dictionary of Occupational Titles in 1991, which is more than 27 years ago, and that makes the requirements in the DOT and its companion SCO publication obsolete, and it conflicts with the regulations because regulations state that work requirements usually change within 15 years. And the datedness of the DOT may serve for the V as an excuse for the V to state that the DOT is outdated and these jobs that they're providing aren't as limited as the DOT states, but then the SSR 004P requires the V to provide or requires the judge or the representative to elicit testimony explaining or that explains the conflict between the V testimony and the DOT. These last few slides address some of the examples of some of the limitations that do not significantly erode occupational base. If you apply it to all work, crawling, kneeling, being at unprotected elevations, inability to feel size, shape, and the like with fingertips, the need to avoid significant amounts of noise or dust and things like that, those aren't significant limitations, and they usually would not erode occupational base at any level. At sedentary level, the frequent contact with petroleum-based solvents, the exposure to pollen, the crouching, stooping, lifting, carrying less than 20 pounds, pushing, pulling, walking or standing for slightly less than 2 hours in an 8-hour workday. They need to alternate sitting and standing so long as the sitting and standing can be accommodated by normal breaks. The use of handheld assistive device for prolonged ambulation, for walking on uneven terrain, for ascending or descending slopes, climbing, hearing, understanding simple instructions, or exposure to hazards. These limitations would not usually significantly erode the occupational base at sedentary level. At light level, crouching, occasional stooping, ascending, descending scaffolds, poles, ropes, inability to crawl on hands or knees, or the need to avoid feathers would not substantially erode the occupational base at light level. At medium level, these limitations are ascending, descending ladders and scaffolds, avoid environments containing objects or substances known not to exist in most workplaces, such as nuclear waste, will not significantly affect the occupational base at medium level. And in conclusion, in analyzing the musculoskeletal disorders and the way they affect the sequential disability process, we look first at proof that the individual does have such disorders, and the agency looks at objective signs and laboratory findings first and foremost. The functional limitations for residual functional capacity that musculoskeletal impairments can have cause both exertional and non-exertional impairments. You should be quantifying the limitations when posing hypothetical questions to the vocational experts, and you can use the medical source statements from doctors, and we provided a sample of that in the slides and also in the written materials. At step 4, you should develop the testimony regarding the physical and mental limitations of past work for the judge to be able to apply the limitations from the musculoskeletal impairments to make a decision at step 4, be mindful of composite work and accommodations. And then at step 5, you should need to pose a proper hypothetical questions and be mindful of the limitations that generally do not erode occupational base at a particular, or do not significantly erode occupational base at the particular exertional level. And that, with that said, that concludes my presentation. Thank you, everyone, for listening. Okay. I have a question. What happened to the previous presentation? Because I came in around 3:30, and then it looks like you guys were skipped me. Okay. All right.
Do you find that the ALJs are more amenable to finding a listing these days?
From my personal experience, let's just say it's hard for me to think of specific examples where the ALJ found a listing. So it doesn't happen from my experience too frequently. I remember a case 2-3 years ago, the judge was asking me for specific evidence showing nerve compression and all that, and the judge ultimately found the client met a listing, but that was probably about the only time that, or the only example that I can think of right now where the judge found that the person meets a listing. So from my experience, it doesn't happen too often.
When you have a case, do you initially strive to meet the listing criteria, or do you present it as like a functional loss to your own occupation? Do you meet it at step 3, or do you just argue for step 5?
We have a packet that is being generated by our case management software. So when we get a client, the client always meets with an attorney, and they tell the attorney about the impairments. And if we think that there is a good chance that the client meets a listing, we would generate a form for that listing, and we would give it to the client, and also ask the client to take it to the doctor, or sometimes we would send it to the doctor directly if the client is more comfortable. So we always, if we feel like there's a good chance, we would give them a form or send the form in the beginning. But again, rarely helps at the hearing level, at least.
If you're still getting medical experts in your area, do you find that they're frequently not prepared to talk about the laboratory findings if it's primarily a musculoskeletal, impairment?
I do find that a lot, and it depends on the expert. I mean, I can think one or two who, off the top of my head, who are not prepared in general in my area. So, and then there are who are well prepared as well. So there's always, we keep a list of the experts as well, and then we keep tabs on them.
Stop there. I'd like to thank Jennifer for putting this together. Thank you, Jennifer.